very novel questions are being raised about Senator Thorpe's validity to serve as a senator. Now, all of this stems back really to her original affirmation sworn on the 1st of August 2022, when there was a little bit of toing and froing on the floor of the Senate chamber involving the Senate President, Sue Lines, and Senator Thorpe. Now, in order to understand where we find ourselves today, why don't we wind back to that date in 2022 and have a close listen to the pronunciation of the word hair or heir as it was printed. This was the swearing in.
I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors according to law.
Okay, so Senator Thorpe has not really commented on that pronunciation of heirs. Of course, Queen Elizabeth II was the reigning monarch at the time. Then we jump forward to her confrontation in front of King Charles III in the Great Hall of Parliament House here on Monday. That gained worldwide notoriety for Senator Thorpe, and it's against that backdrop that we spoke to her yesterday and asked some of these questions about the validity of her affirmation, her recognition of King Charles III as the reigning monarch or King of Australia. It gets rather more complicated from here. Here's Senator Thorpe.
I swore allegiance to the Queen's heirs. If you listen close enough, it wasn't her heirs, it was her heirs that I was giving my allegiance to, and now that, you know, they're no longer here, I don't know where that stands, but...
Right, so what's the significance
I'm not giving
of that?
Up my job. I'm not resigning.
What's the significance of that mispronunciation? I don't know if that's the right description, but in using that phrase, and you did deliberately say heirs as you swore your affirmation in the Senate. What's the import of that? Does it invalidate your oath of affirmation or your statement of affirmation?
I'm not an expert on the colonial laws. The only experience I've had with colonial laws is the violence of them, and the violence of pledging allegiance to the oppressor is absolutely out of date and absolutely a disgusting thing to make someone do.
Greg, I can hear you there trying to make sense of it all on the fly. That's the question that's being asked today. So what have you made of the reaction?
Well, look, there are two lines of questioning that are now opening up, Dan, on the validity of Senator Thorpe's status as a senator. One relates to that original mispronunciation. Let's not go back over that. Then the second is whether she may have actively renounced her original affirmation as she stood face to face in the Great Hall and told King Charles III that he is not my, Lidia Thorpe's, king. Now, there are some serious thinkers in the federal bureaucracy and legal circles who think that is a textbook case of renouncing your affirmation as sworn on the Senate floor. So this is going to be the subject, we are told, of further examination led in the first instance by the coalition. So Senator Simon Birmingham is the opposition Senate leader. We'll put up a section of his written statement. Simon Birmingham saying the coalition will explore options and consider legal opinions as to the implications of Senator Thorpe's admission. So that is a reference to the heirs conundrum that's been created or highlighted by Senator Thorpe. Then, as I said, there are separate questions being asked about whether it was renounced in the Great Hall. Who knows? That might be examined too. We understand that procedurally these considerations, if they choose to consider them, would fall to the Senate President and indirectly, in the first instance, to Government House as well. So that would be Sam Mostyn, the Governor General. Not saying we're there yet, but that's who would make these decisions eventually if that is triggered. Why don't we hear from Senator Thorpe, though? We're jumping forward to today. She spoke on the Nine Network and not for the first time said she's not intending to go anywhere.
No, I'm an independent. No one can kick me out of there. I'm there to fulfil my job. I represent the Black Sovereign Movement, which is about questioning the sovereignty of the Crown, and I'm calling for a treaty. I'll spend the next 3 years getting that unfinished business done.
And so the lines are drawn. Rest assured, this will be the subject of a much more political debate, if not legal opinion at 20 paces. But we do at least have a way left to travel, Dan Borscher, on this story.
My word, we do. Greg Jennett there reporting from Canberra. And for more, well, let's bring in a constitutional lawyer, Anne Twomey, who joins us now from Sydney. And you've been listening on. What do you make of all of this at first instance?
Well, look, first of all, it's a matter for the houses to decide. It's not the sort of thing that can be litigated in the High Court. It's different from a disqualification. So there's not a provision saying that you're disqualified if you renounce your oath or anything like that. If she'd made an oath to a foreign power, that would be a different matter. But as far as I know, she hasn't.
Is that what would come under Section 44? Is that
That's right.
the doomed
Yes.
section that the nation became well equipped with in recent years?
It is indeed. So under Section 44(1), if she made allegiance to a foreign power, then that would disqualify her. But if we go back to the stuff about taking oaths before you take your seat in Parliament, this is in Section 42, it says that every senator shall, before taking his seat, make and subscribe before the Governor-General or a person authorised by them an oath or affirmation of allegiance in the form set out in the schedule to the Constitution. Now, we do know that Lidia Thorpe signed the test roll, and that has the oath or affirmation of allegiance set out in writing with heirs, spelled correctly, and she signed it, and it was witness. So she has actually made that oath in writing. And even to the extent that she might have mispronounced the word heirs by pronouncing the H, and mispronunciation is not itself legally invalidating, she also referred to the Queen's successors. So she has made an oath to the Queen and the Queen's successors. King Charles is the Queen's successor, therefore she has made an oath to him both orally and in writing.
So if I'm hearing you, on the legal grounds when it comes to the affirmation, it would appear that there you don't see that there is a legal question there. It would be whether, in fact, the upper house, the Senate, decides to take its own action over this matter.
Yeah, it's an internal parliamentary matter as to whether or not the person has relevantly taken the oath. I think on the basis that she's taken the written oath and signed it, that's probably enough. But it would be a matter for the House to decide. The other problem here is the temporal one, so the timing issue. This talks about you have to take the oath before you take up your seat. Doesn't talk about renouncing the oath or continuing to express agreement with that oath throughout your term of office. So it's quite possible that this is a one-time deal, that when you take up your seat, before you take up the seat, you have to have done the oath. But if that oath is accepted as valid at the time by the person before whom you take the oath, in this case, the President of the Senate or whoever was in the chair, then that might be the end of it. Now, we have no legal precedent about that, but on the face of the words in the section, that's probably the outcome. It seems unlikely that everyone is required to keep on supporting that oath throughout their term of office. The provision itself is really just directed at before you take your seat.
So that's really implying that once you make that oath, that it stands for the time that you're there, what you're saying is that you don't need to continually be affirming that every day or every time that you take your seat. If that were to be questioned or challenged, could that be something that creates a different precedent?
Well, it would certainly be novel, at least for my morning's research, and to be honest, haven't been doing it very long this morning because I've been doing lots of interviews. But I haven't found any precedents about this. Look, there are precedents about people who refuse to take the oath. So Sinn Féin in the UK refuse to take the oath. They get elected to Parliament, but they can't take up their seats. There are old precedents about people who were excluded from taking the oath because they were atheists. And that's when you could only take an oath. And in fact, Mr Bradlaugh, who campaigned against that and was excluded from Parliament for being an atheist, did succeed in the end to get recognition that you could make an affirmation. In this particular case, Lidia Thorpe did make an affirmation rather than an oath, so technically that's what she did, and that means that you're not swearing before God. There are some examples. Barack Obama, when he was sworn in the first time, the word faithfully got stuck in the wrong place. He did retake the oath, but that was really just to stop people, raising concerns about it or challenges. But there's also an example in Hong Kong in 2016 where people elected to the Legislative Council there did deliberately mispronounce words in the oath to show their lack of allegiance to the Chinese government and were disqualified. So in Hong Kong, that happened. But I've got no precedents for mispronunciation of an oath happening in any sort of Westminster country, at least not that I've found so far this morning.
And just finally, I've had more reason to speak to you over the last 2 years than in the entirety of the rest of my career. I wondered, do you see these conversations about constitutionality actually in a broad, overarching way as good because we're actually talking about this document that doesn't actually get a lot of airing?
Oh, absolutely. I mean, the only reason I do this is for public education. I mean, this particular issue is completely bonkers. And frankly, normally I'd just say, go away. But, it's an opportunity to explain things to people about the Constitution and how it operates. So, yes, that's why I'm here.
And I didn't expect you to say that it was bonkers. Constitutional lawyer Anne Twomey with that professional opinion. Thank you so much.
Technical term, bonkers. Yeah, that's it.